I'm here to discuss House Bill 707. This is a bill that provides relief for religious institutions from the Environmental Protection Agency here in Pennsylvania. DEP has been targeting our churches and private schools and going after and managing their on-lot well water systems. They're going way up and beyond what even the federal government through EPA requires for on-lot water wells. They're stopping by and uninvited and clearly violating the First and Fourth Amendment rights of these folks. They're on a fundraising mission. They're providing, are placing fees and fines on these individuals just because they can. Many of the wells that we're talking about have been in place and on these lots for 50, 80 years or more, providing good, healthy, clean drinking water, water that's even much better than any of the public municipal systems provide. And I believe it's high time that these folks are left alone by the agency. And I invite you to take a look at the following testimony.
We're here this morning because I have been approached by numerous churches in my district who have daycare programs in their churches. And under new regulations, federal and then interpreted by the state, these daycares fall under the Clean Drinking Water Act, which is not unreasonable. So one would assume you would have to come in or produce tests to show that your water is safe to consume. Unfortunately, it's much more excessive than that. We have sanitation officers coming in requiring these batteries of testing that are pretty excessive. And then on top of it, they want a well certificate. And these are some very old churches. If the well isn't constructed in a specific manner, or they can't determine how the well was constructed, the water source is deemed non-consumable. They may not utilize those water sources. So we have the first church that came to me said, all of our testing shows that our water is perfectly fine, it's safe, but they can't demonstrate how this well was constructed. It would cost a lot of money to do that. And now they're told that their only alternative is to drill a new well. It's absolutely ridiculous. And then let's just say they do drill a new well and they have those resources to do it. The department is requiring that they have a plant manager. A plant manager, they'll be required to hire somebody to fill that role. So we're not saying that we don't want the water to be safe and that we don't want our children to be safe. This is excessive overreach. There's no moderation here. I have board member after board member of these different churches coming to me in tears. They're just frustrated because they feel like they're gonna have to close everything down. These are some really affordable opportunities for parents. And I'll tell you, one of the individuals that I have testifying today is from a church where my son went to the daycare program. Perfectly fine. We have never had any issues. Their water's testing fine. We are finding a solution to a problem that does not exist.
What the bill really begins to do is respect the First Amendment rights of our religious institutions. These institutions are not relying on taxpayer funding. The facilities that they own have their own private on-lot water wells. They do test their water, and they want clean water. They want safe water for friends and family. What they want, though, is they want to take on the responsibility and the liability themselves rather than having government dictate it.
Through prayer and patience, we have almost made it through the certification, permitting, and testing. To date, we incurred the following expenses. The well cap replacement was $52, which my husband did the installation, the property chair did the installation of at no cost. The 12-hour pump test by a certified well driller was $2,700. Water test at the end of the 12-hour test were $2,400. A water flow meter was installed at a cost of $32, but the meter was donated to us and the property chairman made the installation at no cost to the church. The expense was for some parts that were needed for the installation. Our daycare incurred a $600 expense for using all disposable materials during that period and buying some water. The other 3 units used bottled water for that period at a cost of approximately $55. Regular tests so far this year, since we've progressed to the next stage, have been 154. So our total costs to date have been $5,993. Since we are so close to certification, we only have one test to go that is not cleared. DEP has started us on a permanent and regular testing schedule included on our timeline that I supplied with everybody. The cost of these tests for the remainder of the year is estimated at $4,865.
First initial contact with a DEP official around 2010 when he stopped in uninvited and unannounced at our privately owned school and knocked on the door. I want to stress that unknown individuals showing up at the school created an ominous concern for the teachers, as I must unfortunately remind the committee. The nickel mine shooting had, at that time, occurred only 3 years prior. The official proceeded to tell the teacher who answered the door that the school was in violation of the PA Safe Drinking Water Act and needed a school representative to contact him. After a representative contacted DEP, and while the school directors were trying to determine the severity of the claim, DEP began sending letters to the school threatening to penalize the organization with indictments. DEP coerced us into signing a consent order and an agreement under duress, with the threat of having to close the school until the case was resolved.
In conclusion, House Bill 707 is a religious exemption bill that fits with the intent of the First Amendment of the United States Constitution. Our school is a private institution that is managed by individuals of similar faith and backgrounds who wish to express their sincerely held religious beliefs through the education of their children. Our school is an entity that is reliant on private funding streams, not public dollars. We simply wish to exercise our religious freedom and manage our religious institutions without oppressive government interference.
What areas are you more stringent than EPA requires?
So there are a couple. Surface water systems require full-blown filtration to remove pretty nasty pathogens. We have been more stringent from day one for surface water supplies. So that's one example.
Get a list of those to us somehow?
Absolutely.
Areas that you're actually
more stringent? Absolutely.
When you use force, you said about your people showing up, but the Supreme Court has already stated that when a government agent shows up, it's implied use of force, and the kinds of things that we heard here today don't bode well for what you were saying about being helpful. But what exactly are you what is the issue that you're trying to correct? Because
Sure.
we see, we've got experiences with 80, 90-year-old wells serving adequately with no problems.
My advice to the community at large, if you have a church and you have an official from the DEP show up at that church and they're not there to worship with you, but they're there to regulate you, don't sign a consent decree without consulting an attorney. And I would ask them to leave my property if they're there to try and regulate you. If they're there to worship, I'd invite them to stay. But if they're there to regulate, I ask them to leave and come back when they're ready to worship.
It's just crazy. We've just gone off the rail on this one, and we really need to rein DEP in and get back to respecting our First Amendment and our Fourth Amendment on these kind of issues. So that's what it's all about.